were predeceased to you, that you'd have somebody in place.
Correct.
Do you ever recommend more than one executor, co-executors?
I don't favor that because I think it could lead to complications if the two executors don't see eye to eye. And if they have equal powers, then that only leads to possible litigation or delay in the processing of the estate.
You have an elderly client or an elderly person who writes a will, has 2 children, and they name one and leave the other out. Doesn't that cause a problem too?
As far as executor?
Yeah.
Sometimes it does, sometimes it doesn't.
Mm-hmm.
But, you know, my thoughts are once you're gone, it doesn't really matter to you at that point, right?
That's their problem, right? Okay, now what about the bonding requirement? There is ordinarily under state law a requirement that an executor or executrix have a bond, typically. Is that right?
That's correct, but you can, in the creation of your will, put a clause in there that waives the posting of a bond by your executor.
Yeah, I mean, that's probably a very good clause to have in a will, because without a will, an administratrix would have to post a bond.
That's correct.
Right? And that costs the estate money.
That's correct.
So another good reason to get a will.
Yes.
Right? Let's talk about the trustee.
Yes.
They're the next person that gets involved. Describe who the trustee, what they do.
The trustee can be the same person as the executor. They can fulfill the same responsibilities.
Mm-hmm.
I usually often advise against it because then, similar to the government, you have your checks and balances. If you have an executor and a trustee, one's not overseeing everything, and there's a less likelihood then of misappropriation of the decedent's estate.
Now, what does the trustee do? What's their main function, and how do they operate? And
the trustee governs any trust that may be set up under a will.
okay.
Specifically, as we talked about before, if there are minor children, instead of the executor making the payment to the minor child, the executor would make the bequest payable to the trustee. If there's no trustees under a will, there's really no need for a trustee to be appointed.
Now, if there is a trustee appointed and there is a trust established, that trustee has to manage a business or sell a business, invest money, and so you would want, I would think, to give the trustee some instructions, as well as the executor, on how to handle what type of risky investments or more conservative investments. And so there are clauses, are there not, that would govern that?
Yes, there's many different clauses that could govern that.
And you can give as much latitude or as little latitude as you want in giving the executor or trustee that power, correct?
That's correct.
My gosh, we have 5 minutes, and we probably have about 3 hours more to talk about.
One thing you missed on there that I would tell you, in addition to an executor or a trustee, is if you have minor children,
mm-hmm.
you would also want a guardian appointed.
Ah, yes.
Because then you get to select who would oversee and take care of the minor children, rather than a possible custody issue being waged among family members.
Okay, let's go in the remaining few minutes that we have to a living will. Okay? There's another name for a living will. I think it's Advanced Healthcare Directive, right? That's what New Jersey calls it. What are those?
An Advanced Healthcare Directive or living will is basically, in a sense, a document that's provided to your healthcare provider that says what you want done in the event something should happen to you, i.e., do you want to be put on a resuscitation machine? Do you want food and water to be given to you? It allows you to dictate your medical preferences, even though you physically cannot convey them to anyone.
Okay, and I guess that goes back to the years when Karen Ann Quinlan, that was
That's
a famous
correct.
case in New Jersey, was in a coma, and the issue of her, right to die with dignity.
Correct.
Right? And they're very popular now. In fact, you can get them in most hospitals before you go in for a major procedure. But who do you appoint as the representative?
I always tell you need to appoint the person, and this may be the wrong term, that can distance themselves from the current situation and will act and carry out your wishes no matter what their personal feelings on the subject may be.
Okay, and you can name alternates as well,
You can
right?
name alternates.
On the ones that I've written, I've actually had co-representatives, like 2 children.
That's correct.
I always thought that was a good idea, because if you name one, that puts the burden on one child as opposed to the 2 children together deciding pretty much the life or death
That's correct.
of a parent, right? So that's probably not a bad idea.
That's correct, but then conversely too, if they have differing opinions, that could prolong the decision that the parent really wanted in the long run.
Yeah, good point. Okay, let's go to powers of attorney. That's probably the third thing that's probably important in what we're talking about: a will, an advanced health care directive, and then a power of attorney. Right? Those are three
Correct.
kind of important estate planning tools you need. Why have a power of attorney?
Power of attorney is necessary because if for some reason you should become incapacitated or incapable of handling your daily affairs, that person could step in even though you're still alive. If you can't handle your finances, they could take care of checks for you. If you can't manage your day-to-day affairs, they can step in and run your day-to-day affairs for you.
Now, if you don't have a power of attorney, and this only governs while you're still alive but incapacitated, if you don't have a power of attorney, it gets quite expensive to have a guardian appointed. Is
That's
that right?
correct.
What happens then? I mean,
You have to essentially probably hire a lawyer for most parts. Most people wouldn't do it themselves. Go in, file an action with the court, seek to have a guardian appointed, and the guardian is the same as the person you would have selected as a power of attorney to come in and manage your daily affairs and keep things going while you become incapacitated or unable to manage your own affairs.
right, you need to get doctors involved to write reports,
Correct.
go to court, have a judge appoint somebody.
Correct. Usually you need 2 doctors' reports, and you have to have a full-blown hearing. Sometimes if you're the person that they're seeking to be the power of attorney or guardian over, they'll make you come into court, and it can be somewhat humiliating for a person who thinks they're doing well, and if asked a simple question like, what day is today, you don't know what it is, or who's the President of the United States as we sit here today. It can be somewhat humiliating for that elderly person that might be in that particular instance.
Susan, we have pretty much run out of time for tonight's show. One last question. Can you go to the stationery store and buy all these documents, or should you see an attorney?
I always recommend you see an attorney because each state has specific provisions. But if you don't know what you're doing and you don't do it correctly, it would render your will invalid. And if your will is invalid, it's the same as though you died without a will, and then your wishes as you may have wanted them are not carried out.
Susan, thank you. Thank you very much for being on the show tonight.
Thank you for inviting me, Mark.
Hi, I'm Mark Gruber. This is Law Talk Today. Thanks for watching, and come see us next week.